Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the differences between paid vacation versus vacation pay for Canadian employees. And in particular, for those employees who've either left their job or lost their job through termination, firing, or layoff. Because the difference in these two terms is particularly important to most Canadian employees. Because you have to make sure that you are being paid, including all your termination pay and all the money that you are owed, that is consistent with the laws of Canada. And when we're talking about the laws of Canada, more often than not, we're talking about the laws of the particular province within which you are employed. But the reason that I bring up Canada so much so is because in Canada, the law talks about vacation pay. It is not a jurisdiction that deals with paid vacation. Paid vacation is a concept from the United States of America. And depending on what state an individual is employed in the United States, there are different concepts with respect to the aspect of paid vacation. And the fact that whether by contract or by some legislation or both, United States employees in various states can be entitled to paid vacation. And they accumulate these vacation days, these paid vacation days, and when they're terminated, they can collect upon their paid vacation. This is not something that you see in Canada, at least in most provinces, in particular in Alberta and Ontario, which I'm most familiar with. In those provinces, you have two concepts. You have vacation time and vacation pay. And when we talk about vacation time or vacation days, we're talking about those days that you're entitled to have vacation on, similar to general holidays or statutory holidays. Those are days upon which you are entitled to have those days off. It's set forth in legislation. And contract can't take it away. All an employment contract can do is increase the number of vacation days that you're entitled to. So you might be entitled to 2 weeks by law, but your employer might say, we're going to give you 3 weeks before the time is to get 3 weeks. It might give you 4 weeks. That is a choice of your employer. Now there's a second concept, and that is vacation pay and general holiday pay, otherwise known as statutory holiday pay to some. And these concepts are tied typically to one's wages. They are not tied to your vacation days necessarily. They are not tied to paid vacation. But for some reason, the concept seems to have gone awry in Canada with too many employers. And we're talking about large employers, in that they work their payroll calculations to try to present the Canadian legislative process, but they in fact work off of a paid vacation system. And so at the end of the day, when employees are terminated, they are paid vacation pay on termination, which is in effect all too often paid vacation. And the concept they have is, if you've banked away a certain number of vacation days and you haven't used them, the associated pay, paid vacation as you would call it, is what is remitted to you upon your termination. Then you need to ask yourself, where does this come from? It might be written in some contracts, rarely, but sometimes it could be. But it is definitely not in the legislation. It is not vacation pay. It is not general holiday pay. It is not statutory holiday pay. It is a concept with no statutory basis in Canada. Yes, there is statutory basis in the United States, and there might be contracts in the United States that reinforce this. But I'm talking to Canadian employees right now. I'm not talking to U.S. employees. If I'm talking to Canadian employees, I'm presuming they're working in Canada. If they're working in Canada, the laws of Canada apply, not the laws of the United States. So why then would you have people receiving paid vacation on their termination? And in all likelihood, when you really dig into it, they're applying that paid vacation concept to all their previous years of employment. And what does that mean? It gets very scary from the employee's perspective if they really knew what they were dealing with. Because they could be losing out on thousands and thousands of dollars. Yes, it might not be that way for some employees that get paid vacation. But that is a concept that has to be looked at, analyzed, and processed by lawyers. But let's get back to it. Why does this happen? And a large part of it, at least in my professional estimation, arises from the fact that far too many employers in Canada rely upon American payroll software. And whether it's that they fail to adapt the payroll software on their own, or the payroll software and their consultants fail to properly assess it and provide them with direction, they attempt to use American payroll software, which is designed to work in the United States and was built for United States legislation, United States contracts, and they attempt to apply it to the Canadian situation in a way that is favorable to the Canadian employer. And in so doing, whether they realize it or not, they are operating on the basis of paid vacation. Even though there is no law, there is no contract that says in Canada, paid vacation is the only form of vacation pay and general holiday pay that employees in Canada are entitled to. It just completely avoids the fact that there is specific provincial employment standards legislation that sets out how vacation pay is to be calculated and how vacation pay is to be made payable, how general holiday pay is to be calculated and made payable, how the distinction is between that and the other forms of payment that an employer receives, how distinct it is from wages. But this is problematic for the software. The software engineers don't fully recognize it. The lawyers don't get involved. The employers don't want to get involved. Why would the employer want to get involved? It's going to cost them thousands and thousands of dollars more per employee if they make this change. What's a payroll software company going to do when they come to an employer? Use our software, it's going to be more expensive for you on your payroll? That's not what an employer wants to see. And if the employees aren't taking any issue with it, and very few do, then what happens? The employees get the shaft. They walk away not having been fully paid. So they get paid vacation as opposed to vacation pay. And because of that, they lose out on thousands and thousands of dollars. This could be thousands of dollars every year. And that's because they don't understand it. And possibly the lawyers they deal with don't understand it. But the fact of the matter is, when you're in Canada and you're employed, the provincial employment standards legislation or the Canada Labour Code for certain federalized businesses dictates how you get paid for vacation, and that is vacation pay, as well as general holiday pay. It is not paid vacation. It is not the United States concept. If your employer wants to pay you based on the United States concept in addition to what the statute requires, that's perfectly fine. They can do that. If they want to give you extra money, that's fine. But they cannot avoid the statutory minimums from provincial employment standards legislation and pay you vacation pay and general holiday pay. And unfortunately, I see it all too often, whether it's in termination packages or it's in pay statements, that employees, individual employees, not groups of employees by them together, but individual employees are losing thousands upon thousands of dollars every year and upon their termination because the concepts are completely wrong. They're transposing United States law into Canada and not applying Canadian law. And if you're working in Canada and you're working in a Canadian province, you got to look to Canadian law, whether it's a Canadian labor code for federalized businesses, or more likely than not, the provincial employment standards legislation, whether it's like the Alberta Employment Standards Code, the Ontario Employment Standards Act, to know what you're entitled to and to make sure that you are paid that amount. And you can't twist it around. You can't say it's integrated into something else. That's not permissible legally. It has to be done right. It has to be done correctly. That's the only way the law allows it. If it's not done, then what the law says is you haven't been paid it. And if you haven't paid it, you're owed it. Because it's your money. You have earned it. The statute says you've earned it. You've worked to the degree that you're legally entitled to it, such as earned money. That is your money. You should be pursuing it. But if you don't recognize this, you don't pursue it, you're not going to get your money. And you're going to let your former employer, most likely, walk away with thousands and thousands of your dollars, which you legally earned and you're legally entitled to, because your employer was in that circumstance using the United States concept of paid vacation when they should have been using the Canadian concept of vacation pay and general holiday pay, which you are legally entitled to because you earned it. Thank you.